Okay, gotcha. Okay, Tatiana, you're currently, as I was just looking up your SIO, that you're at Leiden University. Leiden, is that in Belgium or Amsterdam?
It is in the Netherlands.
Okay.
It's the city of Leiden, but I work in The Hague, so it's the Hague campus, the city of justice and peace. Yeah.
Okay, great. And your position still is the assistant professor in cybersecurity governance, is that correct?
Yes, absolutely. This is it.
And you also rub elbows with people in ICANN, and so you're currently a counselor with the CCNSO, is that right?
Yes, exactly. Virtually, all virtually, but hopefully we will see each other soon on site.
And last but not least, I mentioned in very quickly passing, you were very active with NCUC and probably still are. So did I miss anything else? Do you have a cat or a dog or anything else?
No, I don't have a cat or a dog, sadly, because I can't get one because of extensive travels, which don't happen anymore, but we hope they will resume, right?
Right. Perfect. Okay, well, you let me know when to turn to the next slide. And folks, please type in your questions or we'll open up your mics. And if you have a more elaborate question or comment on anything that Tatiana is saying, so please go ahead.
Thank you very much, Glenn. And good morning, good afternoon, good evening to everybody. We have a small group joining here online, but I hope that those of you who missed it online in sort of interactivity, that you can grab coffee or tea or any other drink of your preference and listen to this lecture. And I must admit that when Glenn approached me and asked me to give a lecture on legal aspects of internet governance and told me that it's going to be only an hour, I thought, well, this is actually quite ambitious, because for those of you who are familiar with law, it might be too basic. For those of you who have no idea about what law is and how law governs internet, in many ways, in all its entirety and complexity, it might be too complex. So in my presentation today, I was trying to bridge this gap and bring these two unbridgeable things together. So let's go with this ambition. And Glenn, if you can go to the next slide. Those of you who are lawyers, please bear with me, because I do have to start when I talk about legal aspects of internet governance. I have to start with a short explanation or short recap for all of you. What is law? What is law? Think about it. Law is the set or system of rules which is created by authority. And law is always created by authority of a state or states. And it is enforced by the same controlling authority, and if necessary, backed by sanctions. What does it mean for us in terms of definition? It means that to establish the rules and to enforce them, the state has to have control, and control is always linked to territory. So your ability as a state to create these rules and enforce them goes only as far as your border goes. We can, of course, talk about international law, international treaties, which are created by a group of states, but still, sovereign states are joining and creating new rules or harmonizing their national laws, but they're not enforcing their own laws in other countries. It's impossible. So law as a set of rules in terms of command and control enforcement authority will always be territorial, right? But when we talk about internet, we talk about global network. We talk about borderless cyberspace. And I think there is no surprise for you, and it is a conventional wisdom, and you've heard it many times in your life, that law and governance by law and setting the rules by law has this tension with global and borderless cyberspace because of the territoriality and sovereignty issues. Another thing I want to bring in here is that there is frequently this debate that internet is just like natural global commons, right? Like another domain in addition to sea, atmosphere, Antarctica, outer space, and has to be governed in the same way, in the shared way. Yes or no? Look at this analogy. Natural spaces, all these shared global commons were created without humans. If we humans will disappear tomorrow, Antarctica will probably not care unless it disappears with us because we did something horrid to it. The same with seas, the same with atmosphere and outer space. But internet, cyberspace was created by humans and for humans. And it's mostly privately owned networks and services. So the analogy with other global commons just breaks down. So we have to look at law differently here. And we have to govern by law, but we have to take it into account. This, different level and different structure and different notion of this global commonality. Glenn, if we can go to the next slide, please.
Yeah.
So what about law and cyberspace? I've heard during my last 25 years, when I studied law and then I did my PhD and worked in telecom and internet law and cybersecurity, that somehow cyberspace is some sort of less governed space compared to online space, or even sometimes Wild West or lawless space. And in fact, it is not. And this is what I want you to know and remember. Cyberspace is not lawless space. Sometimes cyberspace, in terms of laws, is governed even more than offline space, because two types of laws applies, old laws and new laws developed exactly for the internet. Law applies on the internet to human interactions, to business interactions, to state interactions on the internet in the same way. Not, of course, the same laws, but in the same way that laws applies offline. Of course, we have troubles with the mechanisms of enforcement. We have troubles with jurisdictional conflict. We have troubles with finding out whose laws are going to apply. But law does apply. It governs. Law can serve as an enable. Like, for example, enable for privacy, for personal data protection, for your ability to run your own business. For your ability to communicate, law can be an enabler. And law can also be a guardian. Law can protect privacy. Law can protect security. Law can protect business relationship. Law can protect your property, and so on and so forth. And thirdly, law can be an umpire. Law can be a judge. In case of any human or business conflict, we can use law to judge this conflict. So these are the functions of law in cyberspace, just in the same normative way that we had online. And now when online and offline are so closely coming together, sometimes they are inseparable. However, and here the tension lies, we are talking about global borderless space, global common in a different way. And we have states creating the laws within their sovereign borders. And the question is, which laws do we apply, right? Tatiana, you tell us that laws govern cyberspace, but which laws? Who adopts those laws? Which state? In which jurisdiction? Who enforces these laws? And how? Can we go to the next slide, please? So let's just look at the internet development and law. Legal implications could not easily be predicted at the start of the internet. It is very wrong to think that internet was ungoverned, that internet was lawless space at the beginning. It wasn't. It was governed by standards. It was governed by technical arrangements, less by law, as I said. The consequences of this internet penetration, of this ubiquitous connectivity, even the network development could not be predicted to the extent that we have it now. If somebody would have told me 20 years ago when I started my PhD on cybercrime, where we will find ourselves now, well, I would have believed, but it would have been quite futuristic at times. So at the beginning, the normative order of the internet perhaps was not governed so much by law. Of course, it could have been when there was a contract, or when some companies were incorporated on some state territories, or when the crime happened, still criminal law was applicable. But the rules and standards were set in a different way. We had these transnational arrangements, global arrangements by non-governmental stakeholders. And I'm sure that you had already the lecture here on the history of internet governance. And Glenn, correct me if I'm wrong. So you know about the ICANN, who governs domain names in the multi-stakeholder manner. You know about IETF, the organization who set the standards for the internet, the RIRs who are dealing with the IP addresses. So if not law, what was the legitimacy of this arrangement? The legitimacy of these arrangements was their inclusive and multi-stakeholder nature, that these arrangements were adopted in more or less inclusive manner by various stakeholders coming together. So here we have an issue. The law, legitimacy of legal order lies in the sovereign state, in some authority which can set the rules and enforce them. From the early days of internet governance, we also had another governance order, another regulatory arrangements, another order, which was complementary to law, like standards, like the way we govern the domain names. It, of course, could not continue like this alone with the commercialization of the internet. The more internet goes to people, the more e-commerce is happening, the more contracts are there, the more customers are there, users. Law comes into place. And then with all this ubiquitous connectivity, we have issues of political dimension of the internet, of power and control of the states of this open resource, which allows people to speak, which allows people to share opinions freely, which allows businesses to carry on. Then there were security and safety concerns, because we are so dependent on this network and we are becoming ever more dependent. And this all created a huge appetite and a need for law and regulation, in addition to these new multi-stakeholder, non-governmental, transnational arrangements. Can we go to the next slide?
Sure can.
Thank you. So this narrative about lawless internet, about Wild West, is actually very wrong. Internet was always governed first by some non-legal arrangements, which still set the standards and set the regulatory standards, and then more by laws. And now when we look at legal aspects of internet governance, we see a complexity, a maze of various national, international framework, and also other regulatory and governance arrangements. And what we have to remember here is that there is some wrong perception of either making, governance and law equal, like governance is only law. No, it's not. Governance, the term governance, the notion of governance, the concept of governance is much broader than just governing by authority, by command and control mechanisms and sanctions and so on and so forth. Governance is broad. The governance is about coordination. It's about reflection. It's about inclusion of stakeholders. It's about transparency. It's about accountability. It is also wrong to think that law is not governance. Law is the way to govern. So these two concepts relate to each other closely. So law is one of the ways we govern internet, in the way of establishing borders of acceptable, in the way of exercising authority and sovereignty sometimes, in the way of setting the rules. But this is not the only way. Can we go to the next slide? And now, when we're talking about setting the rules, the question is, of course, whose rules, whose laws, who is setting them, who is setting those standards? So in terms of laws, we have, of course, and this is at the core of legal aspects of the internet, or of any law, if you ask me, except a body of international law. We have a set of rules adopted from the national countries on the national state levels within their sovereign borders. And it does govern internet, it does govern online relationships, and it governs offline relationships, where somehow internet serves as a medium. Some of these laws are not strictly internet laws. This is just the entire normative order of a single country that can interact and pertain to internet governance. It can be law of contracts, it can be criminal law, It can be administrative law. And there could be various laws that sometimes govern internet explicitly or relationship on the internet explicitly, way beyond technical arrangements, human interactions, content we post on the internet, business interactions, and everything else. In addition to national laws, we have, of course, international law and international treaty. There is, of course, a huge question of applicability of some international laws to cyberspace, and I'm going to talk about this example in a few minutes. And in addition to national or these international treaties on the UN level, for example, we also have various regional frameworks that states in one region create and agree on in a binding manner to govern some relationship pertaining to internet. Just to bring it from the level of abstraction to something concrete, the European Union General Data Protection Regulation, it did affect all the layers of internet governance, from technical layer to societal and economical layer in many aspects. The Council of Europe Cybercrime Convention, you hear the word cyber, of course it would relate directly to internet governance. African Union Malabo Convention on Cybersecurity and Data Protection, a regional instrument. I think it's still not in force, but still the aim is again here to govern cybersecurity, to govern data protection as a regional framework. In addition to all those laws, and it comes back to my previous point about law being not the only normative instrument, law being not the only governance instrument. So we have regulation by transnational governance arrangements. And here again, I'm going to say ICANN, how ICANN governs domain names, how regional internet registries are governing IP addresses, how the IETF sets standards. It's all regulation by standards, which quite a powerful regulation, right? Or other governance arrangements. There is also regulation by contract, regulation by terms and conditions. For example, when you go on Facebook, on Twitter, they do regulate your behavior by you agreeing to their terms and conditions. And then you cannot, for example, post certain type of contents. There is also such regulation as regulation by architecture. I have a great book here on my shelf by Lawrence Lessig, which is called Code. And basically Lessig was one of first people, I think, who put this concept together, that there is this twofold approach to normative orders. So you have East Coast Code and West Coast Code, right? On the one coast, people are writing laws and regulations, and on the other coast, people are writing code, they're programming. And certain choices of people can be inserted into this architecture and restricted. For example, if you try to, it's called techno-regulation. For example, if you, sometimes when you go on the website, you have to confirm that I'm not a robot, otherwise you will not be able to proceed. So your choices are restricted until you tick the box. But this is the simplest example. There are many other examples how human choices or human behavior can be guided by certain choices done by architecture. And in a way, this is also regulation. This is setting the normative order by architecture, in addition to normative order that we have set by law. Next slide, please. But what we have to remember about law and all these other governance arrangements like terms of services, contracts, and architecture is that law can greatly influence these non-state actors' arrangements. Law can change them. Law can force non-state actors to come up with other arrangements. For example, digital platforms. They used to govern you with terms and conditions differently before. For example, after the General Data Protection Regulation, the term and condition changed because there was this law, the framework from the European Union that basically forced the platforms to do this. But also, platforms are sometimes aligning with national legislation, or they sometimes do these choices themselves. Like, for example, on some platforms, you cannot post nudity or certain type of COVID-related content. This is the choice of the platforms. But some states also restrict platforms from allowing certain type of political content or certain type of speech. So the platform policies are always interact with this law, and they are greatly influenced by this law. And this influencing from law and legal order and sovereign frameworks and also regional frameworks is becoming more and more visible in the recent years. One of the recent examples, I put it on the slide, is the speech of Emmanuel Macron, the French president, as you know, but it's also about French presidency in the European Union, where he says that European Union and citizens should not be rule takers anymore. Europe should go to be a rule maker, which basically does refer to European users and businesses being regulated to a large extent by terms and conditions set by digital platforms. And apparently this is something that Europe wants to change. Whether it's for good or not, this is of course another question, and this is outside of the debate of this group. But nevertheless, this example shows to us that rule makers at the point of authority of the state or regional organizations are increasingly resorting to law as a governance instrument, as the instrument to set the new standards and influence non-state actors' arrangements. In the same way, there are, for example, the calls at the ITU to govern internet instead of the multi-stakeholder manner like at ICANN or RIRs or IETF by the ITU in the intergovernmental manner. So just switch the balance from these non-state actors' arrangements to more like international law, international treaties, something that states can agree on. Next slide, please. What the law is trying to achieve here? What are the functions of law when we talk about internet governance compared to other arrangements? Well, law and the primary function of law is to regulate human behavior. And this includes, of course, behavior of private companies, which are at the end, run by whom? By humans, right? So law is trying to raise the bar of being bad. What do I mean by this? Law establishes the borders of acceptable and backs it by sanctions. Like, for example, do not illegally access somebody else's computer system without permission and intentionally. Or do not post certain type of content, like child abuse material, and do not abuse children, of course. Do not post hate speech, and so on and so forth. And by backing it by sanctions, by penalties, by imprisonment sanctions, it raises this bar of being bad. It raises this bar of undesirable behavior, and it punishes those who actually behaves in an undesirable way. And it also aims to restore the justice when the public order has been violated. So this is the first function of law, to establish the borders of acceptable, to steer human behavior. But law can also enable certain desirable behavior. Law is not only about sanctions and punishments, right? For example, law can provide tax reductions for those who develop new technologies or for startups, if we talk about internet governance. So the role of law here is twofold: enable and also forbid what you don't want. In addition to human behavior, law can also regulate technology. Again, through human behavior, of course, because technology doesn't exist, like somewhere there in a vacuum. It exists because we make it. So the law can prohibit certain developments in technology, or ban import or export of certain technology, or restrict the use of some technologies, or like recent initiatives in some countries and regions to provide rules for transparency and explainability of algorithms or artificial intelligence. Again, it's partially regulation of human behavior, but also regulation of technology itself. And law, in addition to all these, can also regulate state behavior. And this refers to several main areas, Mainly I'm talking about international security and responsible state behavior and obligations of states, being in peacetime or in wartime, like UN Charter and principles of international law. And here we also talk about international human rights law, where states have positive and negative obligations. These are states who have them, not humans, right? States have to protect human rights as a positive obligation, but also to refrain from human rights violations according to international human rights law. So if we scope and sketch the big picture of what law is trying to achieve, a bit offline, but also in direct relation to internet governance, these three goals. Next slide, please. In which areas? And I can just say there are plenty. There are plenty. I just put here some of them that are directly related to internet. But frankly, with all this ubiquitous connectivity, in many ways, a lot of laws will relate to our online behavior in one way or another. But just the most visible areas of law where it pertains to what we call internet governance. Of course, e-commerce, trade, security, cybersecurity and crime, protection of copyright, intellectual property rights, trademark laws, the liability of intermediaries, for example, for illegal content, various frameworks adopted on the national and regional level concerning this issue. Human rights, of course, very important area, be it offline or online. And also, in addition to cybersecurity and crime on organizational level, on societal level, we can also talk about international cybersecurity and responsible state behavior. But as I say, it's just very few areas, and there are many more. And if you look at the societal and economic layer of the use of the internet, beyond the technical layer of internet governance, of governance unique identifiers, you will see that it's just a maze of laws. It's various laws that govern various areas of our lives, where we depend on the internet, which is basically right now almost every area, right? Next slide, please. And just a few examples for you. How the law actually functions here, how the law behaves, because sometimes we do have old frameworks, and the question is, okay, let's say we know whose laws, or we know if it's national or international legal framework, but then the question is, do we need more laws? Do we need to create some new normative and legal orders? Or can we just use the law that exists already? And one of the examples is applicability of international law, of the UN Charter in its entirety, which governs the behavior of states, like, for example, the principles of non-intervention, or norms related to internationally wrongful acts. So what to do? Because it's no secret that states are increasingly using ICTs in the domain of security and warfare and attacks. So on the UN level, the states decided to resort not to creation of new body of international law in cyberspace, but rather non-binding norms for responsible state behavior. And there have been two processes so far. One of them is called Open-Ended Working Group. If you hear this term somewhere, you will probably hear it in abbreviation, which would be OEWG. Another group is a group of governmental experts, GGE. And the GGE group produced quite a few reports over the last decade. And in the recent report, it reaffirmed yet again that international law applies to cyberspace, that state sovereignty and international norms and principles that flow from this principle apply to the conduct by states of ICT-related activities and their jurisdiction over ICT. So existing obligation under international law, yet again, they are applicable to cyberspace. The group also looked at the international humanitarian law. And here we have to make the difference, right? So international law is something that applies in peacetime, and international humanitarian law is something that applies to states which are in the state of war with each other, right? So the group reaffirmed that, again, when it comes to the information and communication technologies, when it comes to cyberspace, the international humanitarian law applies only in the situations of armed conflict. So all the principles that I established there, including where applicable, humanity, necessity, proportionality, might apply. However, they also called for further study on this issue without indicating where this study is going to happen. But the things are moving in this domain. So cyberspace did not become lawless or non-normative, terra nullius space for the states. There is a recognition that information and communication technologies have created some new domain where we have to figure out what to do with the existing international laws and principles that govern responsible behavior of states in this domain. Next slide, please. Another example is international human rights law. Again, human rights which apply offline should be applied online and protected online in the same way as they are protected offline in the physical spaces, right? So that was a landmark resolution of the UN Human Rights Council in 2012, which confirmed this, and it was reaffirmed in 2018. And the new resolution in 2018, which reaffirmed that same rights that people have offline must be protected online, especially in particular freedom of expression. The resolution in 2018 also calls upon states to ensure that effective remedies for human rights violation exist, including those relating to internet, in accordance with states' international obligations, which they have under international human rights law. Whether states are following these obligations is another issue. The issue of the rule of law has always been a huge issue for human rights in various countries. But still, there is a confirmation that the same normative order for human rights from every international human rights instrument applies online in the same way it applies offline. So human rights should be protected. Next slide, please. Now, to wrap up this lecture, I would like to come up with a few examples to actually show you that law can have impact on internet governance, and not only in a way, as we talked before, that law can complement some transnational governance arrangements. So what we have right now is that on the technical layer of internet governance, on the layer of unique identifiers, logical layer, we have these transnational non-governmental arrangements, right? I'm repeating this. We have multi-stakeholder model of governance. There is no one sovereign government who decides on IETF standards, so on governance of unique identifiers. Governments are participating, for example, at ICANN as Governmental Advisory Committee and advisory capacity on the issues related to public interest. So it's all quite balanced in these arrangements in terms of stakeholder inclusions. And this goes into some conflict sometimes with the concept of sovereign states and law and the ability of states to govern by law. It does go sometimes into tension with this multi-stakeholder nature of arrangements on the technical layer of internet governance. And in this regard, the national and regional initiatives to produce some law pertaining internet governance, so to regulate some relationships, can really have a great impact on these multi-stakeholder arrangements. And I'm just going to show you a few examples here. Next slide, please. So the first example I want to talk about is actually the attitude of some nation states to internet. Because in many ways, this global network does create threats for political regimes, right? So internet is being used not only to communicate political oppositions for peaceful protests, but has been used to silence these people. The technology has been used under the sovereign laws, which allow to filter content, to impose some content restrictions, again, to silence dissent, to shrink civil spaces, both sometimes to create some preferences for national businesses, for example. So there is a mix of causes here why governments want to regulate internet. It can be to silence opposition or to exercise some digital sovereignty or some perception of some threats coming from the adversaries, which can shut down your internet because you're not in control over it. And this led to even some sovereign internet laws, which claim not only creation of the sovereign internet within national borders, but also like creation of countries' own domain name systems. So completely separate, management of unique identifiers. The laws can also provide for geo-blocking, and not only geo-blocking of undesirable content, but sometimes, for example, for copyright reasons. So as I said, it's a mix of genuine protection of some rights, but it's also a mix of exercising power and control and oppression. Next slide, please. And I also want to highlight a few regional initiatives which apparently were in good faith and can have really very global impact. And one of them I already mentioned, so the General Data Protection Regulation. So it did have a huge impact on how digital platforms and not only digital, any companies handle data, users' data on terms and conditions. But if we look at the technical layer, we will see that GDPR actually impacted also the governance of unique identifiers. Because, for example, I don't know how many of you heard about the WHOIS database. It existed to check who registered a particular domain name, and it was open. So you could easily check the details of a person who registered a particular domain name. Of course, this is not GDPR compliant in any sense, right? So once the GDPR came into force, ICANN had to actually close this publicly available WHOIS database, and ICANN has been working for quite some time on developing a framework on how to access these data for legitimate purposes. So the General Data Protection Regulation did create some new processes and some new rules in the multi-stakeholder model and some new policy frameworks developed by the ICANN community. Another example coming again from the European Union, but much controversial, is the so-called NIS2 proposal. The proposal which will amend the Network and Information Security Directive in Europe, and which includes quite strict and quite novel cybersecurity regulations, including notification about incidents and so on and so forth, with quite strict deadlines. And this proposal for the directive claimed that the root zone servers are in the scope of the EU directive. Now, the root zone servers, you probably know already, there are 13 of them across the globe, managed by 12 private entities. Managed by 12 various entities. Sometimes they're private companies, but sometimes they're also governmental entities, like some governmental entities in the United States, which manage quite a few root zone servers. So basically what happens here is that by claiming jurisdiction over the root zone servers, there are two outcomes. Either the EU will fragment the governance of the root zone servers because only two of them are in the European Union, in Stockholm and in Amsterdam, and then others would be governed differently. So what to do on the technical layer? You create inconsistency for the global network. And another, of course, opportunity that the European Union would say, yeah, right, now the root zone servers are in scope anywhere. But then good luck to the European Union governing the servers which are managed and run by the governmental departments in the United States. So here we go. So these can have immediate impact on the global governance of the root zone servers, which are one of the cornerstones of the technical layer of the internet. So we don't know. The discussion is now that the root zone servers might be excluded from the scope of the directive, but the directive, the proposal is still in making. So we'll see how it comes out at the end. And another issue here, which has direct relation to the technical layer of internet governance, is the requirement, again, of the NIS2 proposal for the registries and registrars have accurate record of domain name registration date. What's wrong with this? Well, basically, I wouldn't say that something is wrong with having accurate data. Of course, the scope of this accurate data is another issue. The problem for me here is that the European Union, by providing these rules in the law, in the legal framework, is basically overlapping and competing with current process at ICANN, where community is trying to develop policy on the accuracy of domain name registration data. So the law here is steps on the tools of current multi-stakeholder process and arrangements. Again, somebody could say, well, this is good because maybe ICANN is too slow with this. Okay, but somebody can say, no, this is bad, because once we discard these arrangements and adopt the laws in one region, other regions might follow, and they might follow with all countries, and they might follow with much worse laws than we have now. So just setting an example here. Next slide, please. And to wrap up the last example, and I hope that I will leave enough time for some questions here. So another example related to WHOIS, which is not available publicly anymore. And of course, WHOIS was sometime the first step in crime investigation. And now law enforcement agencies don't have access to this information. And as I said, ICANN is currently trying to develop and set up this system for lawful disclosure, for law enforcement, for legitimate purposes. So what happened is that the Council of Europe adopted the second additional protocol to the Convention on Cybercrime, which is really, the convention itself has been a golden standard for cybercrime legislation for many years. And the second additional protocol is trying to improve mutual legal assistance. And in many ways, it's a very balanced document. And the Article 6 of this additional protocol contains provisions on sending the request for domain name registration information. Exactly the problem that ICANN multi-stakeholder process is trying to deal with. The explanatory report about the Article 6 of this additional protocol is saying that the protocol acknowledges that there is a current model of internet governance, that there is development of consensus-based multi-stakeholder policies in this field and on these issues. So the procedure which is set out in this protocol is not supposed to compete with these policies, but supposed to complement them. However, as the policies are still in making, we will see if this is going to be a competition, a replacement, or really complementary. And again, the protocol has been adopted, but it's not enforced yet. And this is still to see how this is going to impact the current models of policy development and governance that is happening on the ICANN level. And next slide is going to be my last slide. So upon request, I planned this presentation, this lecture for 45 minutes, because I know that it's sometimes even unbearable to listen to anything for more than half an hour because of the attention span. So thank you very much, and I'm ready to accept any questions if we have any.
Great, thank you. I see Siva has raised his hand. Go ahead, Siva. You're going to open up your mic and talk. think he's getting his mic opened. Siva, we don't hear you yet.
Tatiana,
Yeah.
can you elaborate more on the role of the Council of Europe and its focus areas, and what type of legislative work that it does? Does it only recommend legislation, or what is the status of its recommendations or output?
Thank you very much, Siva. So the Council of Europe is the regional organization which consists of countries not in the European Union, but much broader, right? Like countries which are not the members of the European Union can be members of the Council of Europe. And primary focus of the Council of Europe has always been, of course, protection of fundamental rights and so on and so forth. However, with the cybercrime, and of course, economic issues and issues of justice. So this is one point. Mutual legal assistance, data protection, they have binding treaties on this. With the Cybercrime Convention, it's a very different story, because Cybercrime Convention went far outside of the Council of Europe. It has signatories like the United States or Canada or some African countries and countries in Asia Pacific region and countries in Latin America. So strictly speaking, it is the document coming, it is the treaty coming from the Council of Europe, but it is the treaty which is signed by governments way outside the Council of Europe. And the status of any treaty of the Council of Europe is binding for the parties which signed it. So it is not recommendations. These are binding norms. This is the binding international law which states who signed this convention have to actually transpose, implement into their national legislation. So this is not something that countries are supposed just, to look at and say, okay, we will follow. No, once they sign this convention, they have to implement, and they have help from the Council of Europe in capacity building and implementation. And the Council of Europe does some implementation studies and implementation reports. So this has been checked. Maybe not every legislation really aligns with this convention greatly, but cybercrime legislation at the national level of the countries which acceded to this convention, but it has a binding status. So it's not something that Council of Europe can recommend, without the country signing it. Some of the Council of Europe countries never signed this convention, like Russia never did, and it's not binding. So if we're thinking about legal status, it will be binding only for the countries which joined this treaty.
Okay, thank you. Siva, you were going to do a follow-up comment or question? Go ahead, Siva. Siva, we've lost you. I think he's okay. He's typing something here. Oh, 1 minute. Okay, while he's doing that, you came up earlier in your discussion with sovereignty, and all the Canadian email runs through the servers in the U.S., particularly Chicago, and that's all subject to the U.S. Patriot Act. So how that becomes a jurisdiction issue. So how does the Canadian sovereignty prevail when emails are succumb to that kind of scrutiny? What's your opinion on that?
Well, Canadian sovereignty here will probably not prevail as long as they can be examined on the US side. And right. Of course, it is the reality that we have to face, right? These Snowden revelations and all these scandals were exactly because of this. Because if you have the flow of data or you have access to data, it might be abused, right? Of course, Canada can potentially pass some laws which will reroute this communication from, the US, which can localize the data. And one of the reasons why we actually have the EU General Data Protection Regulation and Safe Harbor Agreement, Safe Harbor Clause, and in some countries, data localization requirements. It's exactly because of these jurisdictional issues, because you don't want your data to be stored somewhere, or you don't somebody to access the data of your citizens in wrongful way, the way that looks wrongful for you. But here is one thing. Spying on foreign governments and citizens, access to data on foreign governments and citizens is a very gray area, right? Because you can regulate companies, you regulate citizens, but you cannot regulate what foreign governments does. And this is where your sovereignty ends. So, you know, you can try to regulate companies which are in the United States when they deal with your citizens, but it's very hard to regulate the US government with their laws when their national security agencies are trying to access communications with your citizens. It's the question of diplomacy, like, you know, Five Eyes agreed not to spy on each other, this kind of thing.
I think Steve is back. The other question I had was something like the Israeli software Pegasus, which is used for hacking phones. Who is regulating such a software such as Pegasus, which has been put under criticism in the late? So, what's your opinion on that?
So with this software like Pegasus, we just have, you know, these different layers of regulation. So on the one hand, we have regulation of export and import of dual use technologies or like technologies which can be used for spying. This is one area where the states could have actually done much better than they did. Another regulation is national regulation when this software can be used. And if we look at some countries, this software can be used for investigation of particular types of crimes like terrorism or organized crime. And one of the examples of use not Pegasus but another remote forensic software is some cases of organized crime investigation in Europe, like the case of Encrochat. But with Pegasus software, the problem is the rule of law in particular countries as well. Not only the complacent behavior of the NSO group itself, but also the fact that countries which use this software to spy on human rights defenders, on journalists, do not have the rule of law. So this software can be used there by their law. And then again, the question is, how do we regulate it? And I think that the US took the first step by banning NSO. Then there is the legal suit, right? A lawsuit by Meta, WhatsApp, now I think it's Meta, in the US court against NSO group for using WhatsApp vulnerabilities, right, to spy on citizens, on private persons. So there are various layers of regulation, and this is a great question, Glenn, because here we can see how, despite various laws governing and some laws actually allowing this behavior, the restrictions, the bar for being bad can be raised even in one jurisdiction or transborder, like the step taken by the US to ban this to put this company on the blacklist.
Great, thank you so much. Siva, go ahead. I think you may have audio again.
Yes, Glenn. Tatiana, you were saying that President Macron of France took the initiative to say that Europe should not be following law enacted in some other part of the world, but should be making its own law. I'm not quoting you in exact terms. Maybe I'm phrasing it inaccurately, but in effect, you were saying something like that. And so as a result, in line with what he said, Europe had enacted GDPR and now the NIS2, and these are still regional. So whatever and the basis of the idea was that Europe should not be following laws enacted in some other part of the world. But at a future point of time, maybe in 5 years or 10 years, some other region might say that we should not be following Europe's laws and we should have our own laws. And so isn't it appropriate to broaden the scope of Europe's laws, regulatory initiatives to something global, not European? One way is if the Council of Europe is acts on not only for Europe, but it goes beyond Europe. Perhaps whatever internet-related initiatives that are taken by European Parliament and European Commission could be moved to the Council of Europe. That's a strange idea, but that may be an easy way of broadening the scope of Europe's legislative initiatives.
Right. So I see several elements here. Well, first of all, the European Union as one regional organization and Council of Europe as a very separate regional organization with very different mandate. So on the level of the European Union, we have the digital single market, and this idea of digital single market, now this idea of digital sovereignty, and the idea of harmonization of legislation as much as possible. Of course, sometimes it wouldn't be possible. But in Europe, in a way, in a simple way, if I might explain it like this, the countries agreed to give some part of their sovereignty and allow European Union as a regional organization to regulate by European Union legislative acts. There are several types of them. Some of them, are binding immediately. Others have to be implemented. But this is not, this is too much details here. So European Union as an organization developed this regulation, legislation, you name it, acts, normative order for itself, based on the idea that this is binding for its members. When it comes to Council of Europe, for example, the interests differ, and the mandate is different. Council of Europe operates on the basis ad hoc binding treaties, if I may. Of course, there is no such term as ad hoc binding treaty, right? But they develop a treaty like Convention of Cybercrime, and then they wait countries to join. Then additional protocol. The first additional protocol, less countries joined it than Convention on Cybercrime. A sovereign state can have a choice to join or not. In the European Union, if European Union adopted this law, it's obligatory for its members, unless you exit, like the UK did, right? So I see that sovereign interests are so unmatching across the globe, or even in Council of Europe. And sometimes, it's not a secret, even in the European Union, that it would be absolutely impossible and utopic to think that we can come to some sort of global order, good rules or good governance on the level of states. I think the only way for us to come to some good governance is to actually try to develop the arrangements on the multi-stakeholder level, like ICANN, like IETF, and rather look at those models as an example for us, rather than, at intergovernmental organizations, which are much slower, much more driven by sovereign interests, and sometimes cannot even deal with such things as, you can look at the process related to the UN Cybercrime Convention and how it goes, and we are not even sure right now if it goes anywhere. So perhaps not very optimistic, but it is what it is.
Thank you, Tatiana. Just a point. Whatever it was that I mentioned about intergovernmental process was more as intergovernmental processes as complementary to multi-stakeholder process, or intergovernmental processes working through. Okay, thank you.
Yeah, thank you.
Great, thank you all for attending. Thank you, Tatiana. That was an excellent summary and synopsis that you provided today. The recording, I'll send you the recording a little bit later. It'll be added to the pool of other speakers that we had. We've had 60 recordings since we started this. Again, that concludes our session today, and look forward to our session next Monday. Again, thank you, everybody. This concludes the call today.
Thank you.
Thank you.